And we are live at the Code of Conduct Tribunal today, 22nd of January 2019. Remember, the CCT hearing of the CJN corruption case was adjourned to today. And trust me, a lot of things happened today. As a matter of fact, this is the longest sitting based on this particular case that we have ever heard. We actually started roughly around past 10 o'clock. Then there was a 1.5 hour recess, and we are just concluding, and the time is almost 3 o'clock. Now, it was really controversial in there. I mean, Danladi Yakubu, who is the chair of the CCT, made his own pronouncements after listening to summations from the defense counsel and the complainants counsel. But at the moment, we are listening, you are watching Milord here on Roots TV, and we are having this particular episode live from the CCT. At the moment, I have an interesting person here. He serves two main purposes right here. He is a journalist, and he's the head of the judiciary correspondence here in Abuja, and he is also a legal practitioner. He is Tunde Oyeshino. How are you, Tunde?
I'm fine, very well, thank you, Gloria.
All right. You and I sat through the entire process today, several hours. This is the longest we have ever experienced so far on this case. So we already know a few things right now. There have been a lot of, court cases in the past. How many days? 8 days. The Federal High Court and the NIC, the National Industrial Court, had asked the CCT to refrain from hearing this matter because there was a debate on the jurisdiction of the CCT to even hear the corruption case of the CJN. Pardon me because I'm using all the abbreviations, but at least we believe that you have been following this particular story. And of course, Justice Danladi Omar Yakubu did make a pronouncement on that. We want to hear from you, Shegu, from the part of a journalist and a lawyer. What happened in there? What do you think?
Well, the sitting today has to be lengthy, no doubt about that. Every preliminary stage of every matter used to be lengthy because they have to sort out so many things. And like what happened today, some things had been sorted out, at least on the issue of the pronouncement from the Federal High Court, the National Industrial Court, and the FCT High Court, restraining the Code of Conduct Tribunal from going ahead with the trial of the Chief Justice of Nigeria. At the earlier stage, one of our contention was that the Code of Conduct Tribunal with the Federal High Court, the National Industrial Court, and the FCT High Court, they are courts of coordinate jurisdiction. Exactly. And I think this matter has been on for long. This dispute has been long for long. I think it's high time the Supreme Court made a decision on it to decide which court supervises which court. So I think that the chairman of the tribunal today made us to understand in his ruling that the Federal High Court does not have a supervisory role on the Code of Conduct Tribunal. Also, the National Industrial Court does not have a supervisory role. FCT High Court does not have a supervisory role because Code of Conduct Tribunal is a creation of the Constitution, and the Constitution is the ground norm. The Constitution is the ground norm, and I think having said to that, you could realize that there was a dissenting ruling because the member one dissented. He has a dissenting ruling by saying no, even if the judgment of any court is invalid, even if the judgment of any court does not make sense, as far as it is a court of record, a competent court, and that judgment has not been set aside, it should be followed. It should be followed.
Okay, I'm just trying to cut you a little bit because that was a tense moment in the court. All of us were there. Danladi Yakubu was very emphatic when he pronounced that, of course, the Federal High Court, the FCT High Court, and the NIC does not have the constitutional authority to tell the CCT what to do. And, it's a case of jurisdiction, and every court guards its jurisdiction so jealously, and you could hear the emotion in his voice when he was pronouncing that. But really, I think a lot of things changed we thought some things might change when the second member, gave his thoughts, and he was referring to the appeal court ruling, or rather the hearing at the appeal court, which is supposed to take place 24th of of January. That is in 2 days' time. And of course, the CJN had approached the appeal court asking it to, of course, as the CJN, to stop the hearing on his corruption case. And the appeal court said, you know what, let us listen to all the parties on the 24th. And from my little understanding of the law, the appeal court, once a matter gets to the appeal court, everybody is supposed to pause, because I believe it has a supervisory role on almost all the courts except the Supreme Court. So explain that to me, my little knowledge. Does the appeal court have this supervisory role? And if it does, then why did Danladi Yakubu not pay attention to that particular order?
Yes, Court of Appeal has a supervisory role over the Code of Conduct Tribunal, but there are some arguments in some other channels that an appeal does not automatically means a stay of prosecution. When a matter is pending before the Court of Appeal, most especially the ACJA, the Administration of Criminal Justice Act, says when it's a criminal matter, the matter has to continue. And I think that is where Danladi Umar hinged his decision home, that an appeal does not necessarily mean a stay of prosecution. And I think that was what the applicant at the Court of Appeal, that was what they wanted to achieve when they prayed the Court of Appeal to make an oral order stopping the Code of Conduct Tribunal from going ahead, which they now said they are not making at this early stage. Let them all come. But the good thing is this: before the next adjourned date, the Court of Appeal would have sat, and probably at the next adjourned date, the Court of Appeal might make that order stopping what could transpire at the Code of Conduct Tribunal at the next adjourned date.
One thing is very certain: this is going to be a case that we are going to hear for a very long time. This is not going to end. I mean, for at least in the nearest time. Now, the interesting thing is, we have to let you know that at the moment, the CCT hearing has been adjourned to Monday, 28th of January 2019. Now, here's the interesting thing. The Federal High Court also adjourned its hearing on this particular case to January 28, 2019. So we're going to see how that goes. Where is Olanik Beku going to show up at? That's one of the first questions. Although I wonder, he may send a representative, considering that there are up to 43 thereabout lawyers handling this particular matter. Well,
going by the ruling of the tribunal today, whatsoever the Federal High Court, the National Industrial Court, or the FCT High Court, whatsoever they do is null and void.
Yes.
Going by the ruling of the Code of Conduct Tribunal today, except there is an appeal, and of which we cannot rule out. Of course we cannot rule it out. We cannot rule it out. An appeal on this ruling may be taken to the Court of Appeal to look at it.
You do know that the counsel to the complainant, that is Mohammed Ali Umar, he did say, I want to find out, sitting in that court, if he does have that authority. He did say that he had the authority to ask for a bench warrant on the CJN Walter Onolen. I mean, basically saying, because he was absent today, that he has the right to pray the Code of Conduct Tribunal to have him arrested and brought to court. And of course, that was a debate. So the question here is, does he have the authority? And of course, we saw, Olanik Beku very much challenge that. But does he have the authority, and does the CCT have the authority to issue a bench warrant to have the CJN arrested and ensure that he appears in court?
Yes, in a normal case, in a normal scenario, a prosecution counsel has the legal right, the constitutional right, to apply for a bench warrant against a defendant who is not willing to show up in court. So let's settle that constitutionally. He has the constitutional right, and since he has the constitutional right, the tribunal or the court also has the constitutional power to issue a bench warrant on any defendant that is not willingly showing up in court to defend himself.
Do you think we're at that point in this particular case? Do you think we're at that point where the CCT could issue a bench warrant and insist that the CJN Walter Onolen shows in person?
The point we had now, we have not gotten to the point of making application for a bench warrant, because the issue of jurisdiction has not been settled. and that is what the tribunal will be doing at the next adjourned date. The tribunal will be, because the defendant is challenging the jurisdiction of the tribunal to sit over this matter in the first place. And in the wisdom of the tribunal have said, okay, no problem, at the next adjourned date we are going to hear the issue, the application on jurisdiction. Let me know whether I even have the right, the constitutional power to sit over this. If the tribunal assumes jurisdiction, then the next thing is arraignment. Then if at that point, after the tribunal had assumed jurisdiction and the defendant is not in court, now the prosecution now has the power to apply for bench warrant.
There was a tense moment in that court, especially for me. Now, for the media, we have been reporting this particular case, and from day one, that was really how it appeared. And you heard the CUPP spokesperson Ikenga Ugochinyere also insinuate the same thing, that the federal government is using this particular case to send away, to fire, to ask the CJN Walter Onoren to vacate the office. But the counsel to the complainant, the federal government, made a clarification. I don't know, but it felt like a clarification, and it is also sort of in tandem with what the Attorney General was praying the appeal court for just yesterday, which was for Walter Onoren, the CJN, to step aside pending the determination of the case against him. Now, it sounds pretty ordinary, but it feels like it has changed our narrative. And my question to you is, if really that is the case, I mean, this is a criminal case, although some have said it's not a criminal case. That's still a bit of a debate there. But this is potentially a criminal case. And under normal circumstances, he should step aside until everything is settled and then he gets back. So why is the judiciary, why is his counsel fighting against this if it's just a normal thing?
No, there has been several decided cases, and it's a trite law. An accused is presumed innocent until the court says otherwise. A case study was the trial of the Senate President, Dr. Bukola Saraki, in this same tribunal. And all through the trial, he didn't step aside. And at the end of the day, he was discharged and acquitted. Now, there was a scenario at a time. One of the retired judges now, Justice Ademola Adeniyi, was asked to step aside while his trial was ongoing then. Now, he was discharged and acquitted, and he was later recalled. So it's a trite law. It's a trite law. Until the court pronounces someone guilty, he is still innocent. So I think if there is no political undertone there, this is a civil matter. It's not a criminal matter. But what they filed here is a criminal matter. And I presume part of the argument, I'm not preempting them, but part of the argument of the defendant will be that this tribunal does not have jurisdiction to hear a criminal matter, because this tribunal cannot sentence anybody to jail. You cannot sentence it. The highest you could do is to say that the asset that you didn't declare, the federal government, you forfeit it, or you will not hold a public office for so number of years. So it's as if law is being mixed with politics.
Exactly, because I wanted to ask, why was Danladi Yakubu so emphatic? You noticed, I mean, his demeanor was fun. He was laughing when all of the motions were being read out, and when it was time for him to read his summation, it was like we were talking to a completely different person was talking. So why was he so emphatic, quoting the administration of the criminal justice law, that this particular case is criminal and that they have the jurisdiction to hear it, and that his summation or whatever it is he decides on the matter should stand, and no other court should have power over him? It's very dicey, you know.
There are always two sides to a law.
Yes.
He is seeing it from one side, the defendant might be seeing it from another side, and I think at the end of the day, everything will still be passed to the table of the Court of Appeal to decide who is right.
This is one of the most convoluted I don't know about you, but this is one of the most convoluted cases that I have seen. I mean, you have attended way more court cases that I have, but it's quite exciting. It's very exciting, but it's also very complicated, because in the next few days, not just weeks, we could see a big change in this country. And of course, we are leading to the elections, which is just a very few days now. I can't even be saying weeks, just a few days away, and all of this is, playing out. out. You are watching Milord right here live from the Code of Conduct Tribunal, where we just sat through, I think, 4 or 5 hours of the hearing of the corruption case on the Chief Justice of Nigeria, Walter Onnoghen. Now, here are a few things that you need to establish. First of all, Walter Onnoghen was not here, and that was a case. And the court established, the CCT established, that he was served in person on Monday, January 14, 2019. Recall that Monday last week he didn't show up because he was not served in person. His personal assistant received the summons. Yes, the summons. So now that has been set aside, and one of the things that the defense counsel Olani Beku kept harping on were all the other court cases that were out there: the Federal High Court case, the NIC, the National Industrial Court, and the Appeal Court hearing on this matter, which of course we saw and have heard Justice Danladi Yakubu Umar, who is the chair of the CCT, say these courts do not have power over the CCT. We are going to continue to watch this. Please, I want to say a big thank you to you, Tunde. Yes, he is, I repeat, the head of the judiciary correspondence here in Abuja. He's also a lawyer, so he's serving two purposes. He's talking to us as a journalist and as well as a lawyer, a person who understands this law. You are watching me, Lord, and we will continue to follow the story. We will appear in all of the courts, and we will see this to the very end. My name is Gloria Oji Emodi. You stay right here on Roots TV Nigeria.